Yeah.
A lot of people are afraid of death.
Yeah.
I mean, I can tell you, my partner, after our little one was even born, she didn't want to chat to me about a will for the first year.
Wow.
Because there's no valid signed will. It prolongs the process by a year or two. Versus having a signed will in place, you can wind up your estate in a year, 3 months, year and a half max.
Yeah.
Versus if you don't have a will,
Yeah.
it can take 3-4 years.
Sure. Today we're sitting with Chris Schultz, who is a testamentary consultant. Now, the statistics in South Africa is that more than 70% of South Africans do not have valid wills. And Chris is going to speak to that, what the implications of that mean. So if you are watching this video, the likelihood is that you don't have a valid will. And today we're going to talk about why that is significant for you to address urgently, particularly if you have children and people who rely on you financially. So Chris, let's take it away. Tell us who you are, what you do, and exactly how long you've been doing it for.
100%. Thank you, Zola. So basically what I do is, as Zola mentioned, I'm a testamentary consultant. In plain terms, what that just means is I specialize in doing wills and estates. So what I do is generally I sit with a client, go through the will, navigate, guide on what's important, what forms part, what not, what is legally allowed, the fees associated with it. Because a lot of times people think, it's Wills Month, it's free, 100%. We don't charge you to draft a will. We don't do anything for the safe custody, nothing like that. But when someone dies, there's cost implications. May it be an executor fee, a transfer on a house, minor kids. I mean, that's another important thing. We always think of guardians and trustees, but what about the fees implicated with running a trust for those kids?
Yeah.
So, to give you a bit of background, like you said, about 70 to 75% of South Africans don't have any valid wills.
Yeah.
What that means is you've got no actual say about how your assets are distributed, who's going to inherit from you, what they're getting. And, a lot of people think, okay, if I don't have a will, there's no fees.
Yeah.
Unfortunately, that's not the reality.
Okay.
Reality would be that if someone passes, you're still going to have to get an attorney, get a company or whoever to wind up your estate.
Yeah.
The only time that you can bypass that is if your estate is less than 250,000, and that's when the High Court, the Master of the High Court, will appoint a family member or a relative to wind up your estate, because then it's fairly easy. But as soon as your estate is over 250,000, you need a legal person, may it be a company, a lawyer, or whoever to wind up your estate.
Okay.
So let me give you the one scenario. If you've got a will, I can say I can leave to my spouse, to my kids, my brother, mother, whoever.
Yeah.
I've got to say I can leave a legacy
Sure.
to those that are left behind. Versus if I don't have a will, the Master of the High Court decides. And in that regard, what if you wanted to protect your kids? I'm not saying anything's wrong with the Master's judgment or anything like that.
Sure.
But I want your wills and your wishes to your actual wish and your assets to be distributed the way you want it.
Yeah.
So what I'm saying is, let me give you a scenario. If you don't have a will and you've got minor children, a lot of people think, okay, they're going to be okay. Those funds get allocated to the Master's Government Guardians Fund, which is essentially, there's no control, and I can't guarantee in terms of how it will get to them, how the process works. Versus if you've got a will, we can set up a trust for them. We can invest the money. We can actually have a trustee who will manage that money and ensure that we can't replace you, but financially we can make it sound for those that are left behind.
Sure. Actually, I think the maybe big elephant in the room for those who are watching may think that they don't have enough assets to be able to draw up a will. Is it relevant for somebody who thinks the assets are below that 250,000 to be able to set up a will?
So if it's less than 250,000 and you've got minor kids, 100% you need a will. Because if you don't have that will, how can we specify a guardian? The last thing we want to do is let your child go to foster care. And foster care, it's sad. That's all I can say. Versus, I can take control and I can say, your brother, your sister, your aunt is going to look after your child. Because, you don't want it to be a scenario of mom and dad left me without anything, you might not have a lot of assets, but you need to express your wishes so that those know that you wanted to leave something. And, people feel appreciated, or it can go the other way if you don't have a will. And you want to show your family that you love them and you want to leave something to them, even if it's something small. We need to get that on paper, because if not, the master decides.
Yeah. All right. So, Chris, you've explained that very well. I think that even if your asset value is below 250,000, it is still crucial that you still have a valid will,
Correct.
especially when you have minor dependents, because that is the mechanism you can use to nominate the person who will look after the interest of your child. All right. Now, tell us about some of the practical cases that you've encountered where you've seen what the implications are when somebody doesn't have a valid will.
Okay, I'll actually use a personal story.
Sure.
So my mother passed in 2016,
Okay.
and they could not find a valid signed will on system. So it was a case of my dad thought they married in community of property, everything would just continue, and the harsh reality of it was that yes, they were married in community of property. Yes, everything is 50-50, but they have a house, they've got kids. So what happened in the interim or in that that duration of this winding up of the estate?
Yeah.
Firstly, my dad had to get an executor. I'm not going to mention who it is
Sure.
because they did a good job. I'm not going to fault on anything.
Yeah.
But in this scenario is my dad had to transfer a house. He didn't have the funds for it. He needed to pay the executor, the master of the high court. All of a sudden, my dad had to fork out 140,000 rand.
Sure.
And where does your average person get 140,000 rand? I mean, I don't have it in the bank laying around.
Yeah.
I don't think a lot of people do. And, as a result, you had to end up selling the house,
Yeah.
selling cars,
Yeah.
just to pay these fees. And I mean, if you've worked 20 years of your life and you've got a year left on a bond and you have to end up selling it, it crushed him.
Yeah.
And as a result, I don't know how to say it in a nice way, but he actually lost it. He lost the plot.
Yeah.
Ended up having to sell the house, got the insurance money out,
Yeah.
spent it, didn't think long term.
Yeah.
And as a result, we're sitting in a scenario where he's 55, 56, has to restart in life. And at that point, it's too late.
Yeah.
Versus if you had a valid signed will,
Yeah.
sat with an advisor,
Yeah.
got everything in place,
Yeah.
he would have been in a completely different scenario right now.
Wow.
And that to me, out of personal experience, I've had it now with a family member recently again.
Sure.
They signed the will, or but they didn't date it, and they also didn't put any two witnesses on.
Yeah.
Which means the will was invalid.
Yeah.
The company that was the executor on record
Yeah.
didn't want to do it because they aren't nominated as the executor.
Sure.
So legally they can't do anything.
Yeah.
Now they had to find an attorney. To find someone to do it afterwards could be quite complicated because there's no valid signed will. It prolongs the process by a year or two. Versus having the signed will in place, you can wind up your estate in a year, 3 months, year and a half max.
Yeah.
Versus if you don't have a will,
Yeah.
it can take 3-4 years.
Sure. Yeah.
So to me, that is just crucial to get that signed will in.
Yeah.
A will is great, but it needs to be signed and valid.
Yeah, no, absolutely. So just talk us through that technicality of the validity of the will. Because maybe some people think if they have told somebody what their wishes are when they pass on, that, it's valid. Or if they have written down their wishes on a piece of paper and put it somewhere, that it's valid. Can you talk us through what are the technicalities or
100%.
legalities around that?
100%. So look, I'm not saying don't write down your wishes, don't do that. What I'm saying is have someone professional do it for you, because there's certain clauses and ways the Master of the High Court requires us to actually furnish or structure a will. I mean, there's certain things like Kalaisho, what just basically means if there was any loans that you made to a family member that they don't have to pay it back. There's stuff like protecting your family. So let's say I leave to you, we're married as an example, and I pass away, my parents, you don't want our kids to have their spouses get their hands on anything. There's inheritance exclusion clauses. There's a whole bunch of stuff that needs to go in to protect the family.
Yeah.
But regarding it being valid, firstly, you need to sign each and every page. And the testator or testatrix, we need to get 2 independent witnesses. That can be anyone who's not mentioned in your actual will. Reason being is, if you have a family member or a beneficiary sign, or the executor themselves had to sign on the will, that will be invalid. It sounds stupid, but there's certain legalities we have to follow.
Sure.
Let's say I leave to my wife and she had to sign as a witness.
Sure.
She would essentially be signing away her own inheritance.
Really?
And we've come across it a few times.
Sure.
And as a result, families are broken up, destroyed, and they can't actually get their wishes executed. Certain things people want in wills, I mean, we've got our pets, we've got things, but realistically, we can't control that.
Yeah.
That's where I would say do a page with your last wishes to your family to say, I want my pet to go here. I've got maybe a lounge suite or something specific I would leave to someone. I'm not talking about your assets, your car, vehicle, stuff like that. We can control. But the small things, I would say, write a letter or a last wish form that we can do as well, just to let the family know.
Yeah.
Because if we don't have that in place,
Yes.
nobody's going to know.
Yes.
And on top of that, if you don't have a valid will, we're back to being without a will again.
Yeah.
And then the master decides.
Yeah. Yeah. Thank you very much for explaining that so well. Now, the next question would be, what is the process for one to set up a will? So now someone who's watching, they're thinking, wow, Chris, you've really educated me. So what is the practical step that I now need to take in order to start the process of drawing up a valid will?
Well, firstly, I would say, listen, get in contact with your financial advisor. Because your financial advisor is generally your first point of reference. I mean, that is the person doing your finances, managing your stuff, planning for your death, for your wealth creation, all of that. So generally, once you've got in contact with your financial advisor, they can advise you on the process itself. Otherwise, if you're someone who doesn't have a financial advisor, I would recommend go onto a website, Sanlam, Capital Legacy, have a look at what's in store, what we can offer you. As a result, I mean, you can come to us directly via your financial advisor. We set up an obligation-free meeting to say, listen, let's chat about your will. What can we do for you? There's nothing to say you have to go with the company. You can explore options. But at the end of the day, rather be informed and sit with someone who specializes in it versus trying to do a handwritten will. I had a scenario yesterday with a client whereby she did a handwritten will. There was no ID number. There was no clauses. There was no signatures. And she thought it would be acceptable. Versus if you had to sit with your advisor or, someone who specializes in it, they could tell you, listen, this is not going to work. So setting up, sit with someone, go through it, go through your list of assets, see what you want to do. When you sit with your advisor, they can tell you what's the implications going to be when you leave certain assets to certain people. And that way we can plan your estate for you.
Wow. Thank you. Thank you once again. You've explained that brilliantly. Now, when somebody has gone through the process of consulting with their advisor and now they need a specialized person like yourself to sit with them to go through the process, just explain what will happen in that meeting.
Okay, so if I had to sit down with a client, right, if the client's referred to me, firstly, I would break it down for you to let you know I'm going to draft a will for you. It's just a draft will. We can obviously change things. We can work it in your favor. I will tell you what's legally allowed to go into the will. There's certain things a person wants to stay clear of because there's bad financial implications. A lot of times people think living rights is the way to go until they find out about the financial implication. So, I can sit with you and I can do everything. You basically give me what you want to put into the will. I'll ask you, do you want to be buried, cremated? Have you got kids, guardians, trustees? I run through everything to make sure that you've got a comprehensive will in play. Then afterwards, I'll sit with you and I'll say, listen, based on the structure that we've got here and your list of assets you've presented to me, this is the financial implication, an executor fee, transfer on your house, the master, advertisement. If you've got minor kids, trust fees, taxes. We always think that, the tax man is just there. The tax man is very real. Taxes in life, death, it's a real thing. So I then come up and I can provide you with a solution. Or if I'm not able to, I will put you in contact with your financial advisor. We'll be able to fill those gaps for you to make sure your loved ones are taken care of when you're not here.
Thank you very much. Now, you've explained that when you go through the process of, getting the clients to give you the assets, and that will inform the estimated costs that will be involved in the event of death. Now, what happens when a client passes away and they've not made provisions for those costs, as you mentioned, executor fees, master's fees, transferring of property, vehicles, or if there's firearms and all of that stuff?
So look, that's where it gets very sad, Zola, is because if you don't have liquidity, when I say liquidity, you need money to pay these fees. If there's no money, life cover, investment, something that we can take to absorb or pay these fees, the company is generally going to start selling your assets. Not to say that they will, they're obviously going to ask you how you would cover the shortfall. But if you don't have any way to cover the shortfall, like I said earlier, my dad had to sell the property because he didn't have the liquidity available to make provision for this. And like I said, if you've worked your whole life giving up what you've done,
Yeah.
it's sad. I mean, it puts you back 20 years in life versus if the correct planning was done,
Yeah.
you would be A for away.
Yeah. Now, many people think, well, I've got life cover and I've nominated, my children as beneficiaries or, my spouse or extended family or whoever. So they will have enough money to be able to cover those fees. Do you think that is a valid solution to address that need?
It depends what your life cover is for.
Okay.
So life cover is a brilliant liquidity tool. I mean, that can put cash in hand when you pass to make sure that your loved ones are taken care of once you are gone. I'm not saying don't have life cover. I love life cover. I mean, I've got FILE personally.
Yeah.
That's to make sure when I pass, any debt that we've got is covered, that my wife can still carry on living the lifestyle that she's accustomed to.
Yeah.
And I mean, yes, it can cover those fees. But also, what if you want a certain amount paid and I'm coming from the estate or the company that's winding up your, your estate, and I'm taking 500,000 or R1,000,000 out of that, and you had only R1,000,000 or R2,000,000, R1,000,000 or R2,000,000 life cover. What does that leave the family with? Is that a scenario you want them to think, oh, he left us R1,000,000, but we've now got nothing left of it. So we need to determine firstly, is your life cover sufficient?
Sure.
Have you got sufficient investments to cover these fees? If yes, then by all means.
Yeah.
Alternatively, where I work, we do have a liquidity tool that we can offer that can cover these fees for you. So your life cover can remain untouched and be there for the actual reason of debt, liabilities, bonds that need to be covered. Because a lot of time people think, okay, we're just going to carry on with the bond. What if you can't afford the bond? Then you're stuck in a scenario again. So your life cover could be used for different reasons.
Sure. Well, I've also heard of cases where, a couple, they have life cover. The one spouse passes away. The life cover pays out to the other spouse. But this other spouse does not use the life cover to pay the fees.
Correct.
Why? Because, for example, they've had children from other relationships who are going to inherit in the estate. But the other spouse has liquidity for themselves to survive, and they're not so worried about what happens
100%.
to the other dependents and so on, which can cause immense, struggles and suffering. Have you encountered cases similar to that?
100%. So I recently had something whereby, and this is sad, husband and wife were married. The husband actually had 2 kids outside of marriage, and he made his wife the sole beneficiary of his life cover, which I think was R1,000,000 or R2,000,000 that paid out. But in the interim, what am I going to do as a parent? I want to make provision for myself and my children. Now, what happens to the 2 kids outside of marriage? They are left with no one to provide for. And in the same scenario, if that spouse is not going to use that money, you're not going to be able to wind up the estate. If the estate is not wound up and she had to pass, then the kids are going to sit with it again. And then it's not just going to be a year or 2 to wind up the estate. Because first we have to wind up the original estate, then the second spouse's estate. And that's how sometimes we hear about estates taking 4 or 5 years. That's how we end up in these scenarios. But if money is not used for that purpose, I mean, I've seen people go through 3-4 million rand in a year. Because they grieve in different ways. And some people splurge, others might use it for the right reason. But you'll only know once you're in that scenario. Because we don't know what death will do to us of our loved ones.
No, absolutely. Now, talk us through scenarios where spouses pass away in close proximity to each other. What are the implications for administering an estate like that? A couple married in community of property and they pass away close to each other and there's minor children involved in there.
Okay, so let's say husband had to pass away, and then, let's say generally there's a clause in the will to say that the spouse has to survive you by 30 days in order to inherit, because there's no point in me leaving to my spouse, but she's, going to pass away, and then we have to move the funds again. So if both spouses had to pass in a short space, and there's minor kids, that's where those funds will go into a testamentary trust. And that's only to make sure that the kids are taken care of up until a minimum age of 18. I do recommend older because at 18 I know what I was doing. I'm a guilty party to that. So I would say it's happened before, especially in the COVID time we faced it quite often. And if there's no provision made, the kids are stuck and they've got no way to pay school fees. And then the guardians who were ever left behind might not have the actual funds available. Versus if we had life cover or something pay out, had it in the trust, those fees could be covered, which will take the burden off. I mean, I also don't want to leave my daughter in a scenario whereby other people have to provide and it puts strain on them because they didn't bring our kids into this world. We did. So I feel like we need to take responsibility for these things.
Yeah, absolutely, absolutely. The key word there is responsibility, and taking responsibility to making sure that we make provisions for these things, right? So take me through the implications of these costs now for the average person. You know, let's say they've got a property in the suburbs with let's say 1.2 million. They've got 3, minor kids, and they've got 1 or 2 vehicles. What would be the average cost of administering an estate? Let's say the total value is about 2 million. And if they pass away, they want to make provisions for minor kids through a testamentary trust. Could you give us an idea?
100%. Look, it won't be exactly, because obviously I'll need to do an analysis. But I mean, on a 2 million rand estate, if we work on a 3.5% plus VAT, which is the max tariff an executor can charge, that's already putting us at 80,000 rand just for the executor. If we've got a property of about 1 million, 1.2, you're looking at 20, 30,000 rand in transfer fees. You've got the master of the High Court, you've got advertisement fee for the newspaper, rates and taxes, correspondence, which is the company administering your estate, going down to the master. And you've also got a firearm search, disbursement, which is basically the attorney. Yes, we pay them to transfer the house, but the attorney needs to be paid for the actual job that they are doing. If I start adding these fees up, we could look at 140, 150,000 rand, easy, if not more. Then if we look at minor kids, because now we have to leave it to a testamentary trust. On 2 million rand, let's say the kids are 3, 4 years old, needs to run till 18 or 21. That could be 500,000, 600,000 rand, easy, in trustee fees. And a person might think, hey, this is a lot of money. Yes, it is a lot of money. But if I put it into perspective, we are managing your child's money for 15, 16, 17 years. We're investing it, or your financial advisor is investing it. We are providing funds on a monthly basis to cover their essentials or day-to-day needs. Now, 15, 16 years to take that amount of money is not that much. But, I mean, once again, we're going to be short almost 1 million rand if 2 people pass and we sit with, the testamentary trust. So out of 2 million, I'm taking 1 million rand. What are the kids left with? And that's what we need to take into account.
I think that's a point where many people don't appreciate that, even if you do have a valid will and maybe you've stipulated that a testamentary trust will be formed, but the costs involved, I think you mentioned that earlier, that the cost implications that are involved is something the average person doesn't really understand or take into account. Why do you think that is? I mean, is it a lack of transparency from the profession as advisors and specialists? What do you think needs to change for the public to be more informed about these things?
Well, I mean, I can give an example. Generally, if you go and you do your will, people will tell you that you're going to pay a percentage to the person who's administering your estate. So may it be, PTY, Chris at PTY Limited and Associates, whatever. I would just say, listen, I'm going to charge you this. And then people think that's all they're going to pay. They don't think about the small little fees, the transfer on the house, the master. And I'll be honest, it's because people aren't informed. And, I feel it's our job as the specialists in the field to advise our clients on this. But the client also needs to be open to it, the discussion. A lot of people are afraid of death. I mean, I can tell you, my partner, after our little one was even born, she didn't want to chat to me about a will for the first year. And it took some, persuasion and showing her the cost implications to convince her to say, listen, let's do this thing, let's plan it out. And it might only take an hour or 2 out of your day, sitting with your advisor or, a consultant or whatever the case. And once that is done, it should give you that peace of mind as well, to know if I drop dead, my family's taken care of. Because the last thing you want to do is leave them in a scenario where they get a fright of not knowing what's coming and no provision made for it. And that happens very often, Zola.
But Chris, you mentioned briefly about the solution now to address the cost implications of death. Can you talk us through in more detail? You know, if I pass away, I want to make sure that those fees are sorted, that my wife doesn't need to worry about having to fork out money from her own pocket to pay the master, the executor, and all of these other fees. Can you talk us through that in detail, please?
100%. So what I do is, like I mentioned, I would sit with you, do your will, give you the structure. Then I would ask you what assets you've got. May it be a house, a car, life cover, pension, investments, whatever you've got. Once I've got that together, I can actually do a nice estate calculation, which will show us each and every fee that's going to be applicable to your estate.
Yeah.
And once I've determined, may it cost 50,000, 100,000, R1,000,000, I can come forth and say, I've got a solution to you.
Yeah.
So instead of having, maybe you can't afford life cover,
Okay.
and we can come in and say, listen, for an affordable price, I can take care of these fees, pay a small cash contribution out to your family. And I'm not saying use it for a funeral or whatever. It's just to make some money available.
Sure.
Because a lot of times people think, hey, everything's just going to carry on. No, things can get frozen. And you might sit in a scenario where you've got access to no money. Where I can come, I take that estate or the estate fees, I take it off your plate. And I put cash in your pocket right there and then to make sure your family's taken care of while we wind up the estate.
Right.
It's not an expensive product, but it also depends on what your needs are.
Yeah.
So, I mean, it's called a protection plan that covers essentially all your fees upon death.
Wow.
And that way, you know, once you pass, your wife and your children are taken care of. And that should at least put you in a better position mentally, and as well give you that peace of mind.
Okay.
And once again, it comes down to responsibility.
Yeah.
Because it's that attitude of, I'm not here, it's not my problem. Yes, you aren't, but your family is your responsibility.
Yeah.
So it becomes your problem.
Absolutely. Thank you for that. And then what would happen when death does occur? How would the product then take effect in practical terms?
Okay, so we would essentially ask for a death certificate. Once we've got the death certificate, we can go down to the master, we can get a letter of executorship. Once we've got the letter of executorship, we can come to your family, we actually come to your home, or you can come to our office, whatever works for you. And we can sit down and have our attorney go through the actual files and, you know, do the paperwork with you, instead of you having to contact a call center and struggle. Because, I mean, I like the personal aspect of someone coming to you, to your home, and, you know, that's one person you deal with.
Yeah.
So that's the one part.
Yeah.
Then we need to look at fees.
Sure.
So where you would have had to pay an executor fee, a transfer fee, we actually indemnify these fees. What that just means is we cover these fees for you. We don't pay out a cash value, but we cover the fees from the actual policy that you've taken. And then there's a cash component that will pay out to you. Look, if you're over the age of 60, unfortunately no cash component.
Okay.
But if you're under the age of 60, there's generally a cash component that pays out to relieve some pressure as well.
Okay. Thank you very much. I think, Chris, you've touched on a lot of important components around the administration of an estate, the importance of having a valid will, and I think you've done an excellent job. And now the next question is, how does someone get access to you? I think earlier you mentioned that either it would be via a referral from a financial advisor.
Correct.
Or is there any other alternative way?
We are right across the country.
Okay.
And even if you are in some outlying area or something that we might not be in, we can always service you via Teams meeting, a telephone call.
Yeah.
We will accommodate as far as we can.
Brilliant, brilliant. So it's not just limited to your own geographical location. Anywhere in South Africa, you can access the service of a specialist like yourself.
100%. Even if you're sitting in, I had a client in Russia the other day.
Really?
But he's got assets in South Africa.
Okay.
So we had a Teams call, sorted him out,
Yeah.
and he's as happy as can be because he knows if something happens, he's willed that side because it's not a common law country. We'll
Yes.
take care of his things that side.
Yes.
When it comes to South Africa, we will be administering from this side.
No, brilliant. If you want to get in touch with Chris, as he mentioned, it would be best done via your financial advisor. If you don't have one, we are happy to at least recommend one for you. If you leave your details in the comment section below, we'll certainly be able to assist you there. Or if you want a more private and personalized sort of method, I will leave an email address in the description below that you can leave your details. which then will be given to a professional who will be able to get you in contact with a specialist like Chris, regardless of where you are in the country. Chris, it's been really informative. Thank you very much.
Thank you, Manila. I appreciate it.
Yeah, your wisdom and your insights there.
Thank you for your time.
Yeah.